Recording. Good morning, everyone, and welcome again to what has become the cockpit of academic research at the National Open University of Nigeria. Today we have one of our colleagues who is also the Dean of Law. He is primarily resident and he has not migrated. He's resident in the Department of Jurisprudence and International Law, Dr. Adakule Odike. The title of his presentation is Migrating to Work, an insight on the legal protections for migrant workers and members of their families. Doc, you have 30 minutes. As you know, we have to migrate at exactly 12 to another committee meeting. I thank you for your presentation. After 30 minutes, we'll have comments, and then we'll have comments and questions. I've asked you to unmute yourself, sir. The Dean of Law.
Okay, I've done that. Thank you.
So you have 30 minutes. You can go ahead.
It's all right. Good morning, everybody. Before I commence our discussion, please permit me to give honor to whom honor is due. First on my list of honorees is the management of the National Open University of Nigeria, ably headed by our own double professor, Professor Abdallah Uba Adamu. Next on my line of honor is the director of the Young but Vibrant Center for Excellence and Migration, Center for Excellence in Migration and Global Studies, Professor Hakim Atijani, an ideal friend and mentors to many. My respect also goes to all professors in the house, all deans of faculties, all heads of departments, academic departments and units, my colleagues in and outside the university, and my learned friend. But before I commence our discussion proper, please once more permit me to preface our discussion with a lesson about migration I learned from 6 birds in a park. Somewhere around the lower banks of River Benue, there is a natural habitat for migratory birds. And over the years, the bird developed a migratory pattern which they strictly adhere to. This is the pattern. 1. In every January of every year, they will migrate from various places in the Benue Valley to their natural habitat to lay and hatch their eggs. Number 2, in every April of every year, they will migrate from the natural habitat to reside with other birds that live in the minarets of a mosque in another town within the Benue Valley. 3, in every September of every year, they will migrate from the mosque to reside with birds that live in the cellars of a church cathedral in another town within the Benue Valley. And number 4, and in every December of every year, they will migrate from the church cathedral to a park in another town within the Benue Valley. While they were there on one fateful December, they witnessed a huge commotion down below. And the following dialogue ensued between 6 birds, which I want to share with you. Bird number 1, who are these people? Bird number 2, they are Muslim and Christian pilgrims in the park. Bird number 3, why are they fighting? Bird number 4, they are fighting for a worship space. Bird number 5, but we birds don't fight for space. We move from our natural habitats and stay with other birds at the mosque and cathedral without a fuse. Bird number 6, don't mind them. We birds can do better what human beings cannot do. The take-home value of the lesson is that migration is inevitable and it is essential for survival. Let's begin our topic proper. Understandingly, migration is not an exclusive preserve of human beings. This is because other animals also migrate. Human migration is the movement of person or persons to a new area or country apparently with the aim of finding work or better life. In every settled human society, economic, cultural, religious, and or external migrations and immigration, do trigger internal or external migration. And in migration, there is a crossroad between voluntary and involuntary migration. While voluntary migration is usually as a result of desires, involuntary migration is as a result of necessity. The embracing nature of migration makes it an issue of international concern. Hence, the International Convention on the Protection of the Rights of All Migrant Workers and Members of their Family. The paper, using doctrinal approach, hinges its conclusions on case laws and status while discussing migrant workers and members of their family. This is with the intention of aiding the understanding of the legal protections for migrant workers and members of their family. For the sake of proper understanding of the paper, it is imperative that we commence our discussions on the subject matter with a brief explanation of the keyword used in the paper. In this context, state means a sovereign country or a nation. State of transit means any state through which the concerned migrant worker passes on a journey to the state of employment or from the state of employment to the state of origin or state of habitual residence. State of employment means a state where the migrant worker is to be engaged or has been engaged in a remunerated or paid activity. State of habitual residence means the state where the migrant worker has been physically present for sufficient amount of time. And state party means the state or country that have ratified or acceded to the International Convention on the Protection of the Rights of All Migrant Workers and Members of their Families. The committee means the committee established by Article 72(1), subparagraph 1 of the International Convention on the Protection of the Rights of All Migrant Workers and Members of their Family to monitor the implementation of the provisions of the convention. The International Convention on the Protection of the Rights of All Migrant Workers and Members of their Families, hereinafter called the Convention, is also known as the United Nations Convention on the Protection of the Rights of All Migrant Workers and Members of their Families. Nigeria ratified the convention on 27 July 2009, and upon that ratification, the provisions of the convention became binding on her as a state party. Tied to the above, Article 84 of the convention requires Nigeria as a state party to adopt legislative and other measures that are necessary to implement its provision. The principle that the state party is bound by the provisions of any international treaty that it ratified or acceded to, except there is a reservation to the contrary, influenced the decision of the Supreme Court of Nigeria in Abacha against Gani Fanemi, when it held that since the African Charter on Human and People's Rights has been ratified and domesticated by the National Assembly in accordance with Section 12 of the 1999 Constitution of Nigeria, as amended in 2011, Nigeria courts have jurisdiction to apply its provisions as domestic law with special flavor. The same judicial view will be applicable to the application of the provisions of the convention in Nigeria, if such case should arise. A cursory peep at the preamble to the convention clearly shows that it embodies the basic virtues of United Nations instruments concerning human rights. For example, the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, Cultural Rights and Cultural Rights, the International Conventions on the Elimination of All Forms of Racial Discrimination, the Convention on the Eradication of All Forms of Discrimination Against Women, and the United Nations Conventions on the Rights of the Child. Equally infused in the Convention as its guiding principles are the principles and standards set out in the framework of the International Labour Organization, especially the United Nations Convention relating to migration in abusive conditions and promotion of equality of opportunity and treatment of migrant workers, number 143, the recommendation relating to the migration for employment, number 86, the recommendation relating to migrant workers, number 151, and the United Nations Conventions relating to abolition of forced labor, number 105, which protect the interests of migrant workers employed in countries other than their own states of origin. The United Nations, desirous of ensuring the adequate protections of the rights of all migrant workers and members of their family, reaffirm and establish basic norms in a comprehensive code that is universally applicable in form of the convention. Article 88 of the convention prohibits the exclusion of the application or any part of it by a state party that has ratified or acceded to it. This is, however, without prejudice to Article 3, subparagraph A to F of the convention, which exclude investors, students, refugees, diplomats, etc. Except as otherwise stated in Article 3, A to F of the convention, the provisions of the conventions are applicable to all migrant workers and members of the family without distinction of any kind, such as sex, race, color, language, religion, conviction, political or other opinion, national, ethnic, or social origin, nationality, age, economic position, property, marital statute, birth, or other statutes, migrant workers and members of their family. According to Article 2, paragraph 1 of the convention, the phrase migrant worker means a person who is engaged or is to be engaged or has been engaged in a remunerated or paid activity in a country or in a state of which she or he is not a national or a citizen. Article 2, paragraph 2A to H of the convention states that a migrant worker could be, 1, a frontier worker, that is, a migrant worker who retains his or her habitual residence in a neighboring state to which he or she normally returns every day or at least once a week. 2, a seasonal worker. 3, a seafarer. 4, a worker on offshore installations. 5, an itinerant worker. 6, a project-tied worker. 7, a specific employment worker. 8, a self-employed worker. These are the type of workers we can have as migrant workers. These are the type of migrant workers we have. Now, members of the families of migrant workers. Article 4 of the convention defines members of the families of migrant workers as persons married to migrant workers or having with them a relationship that, according to applicable law, produce effect equivalent to marriage, as well as their dependents, as well as their dependent children and other dependent persons who are recognized as members of the family by applicable legislation or applicable bilateral or multilateral agreement between the states concerned. Non-migrant workers. Article 3, A to F of the convention provides that the phrase migrant workers shall not apply to the following categories of persons. 1, persons sent or employed by international organizations and agencies, such as envoy, diplomat, etc. Persons sent or employed by a state or on its behalf outside the territory who participate in development programs, such as, in Nigeria, we have the Technical Aid Corps, you have the USAID, you have the DFID. All these kind of people are not workers in this kind of category, are also not considered as migrant workers. Refugees, stateless persons are also considered not as migrant workers. But once a refugee take up job in the state of employment, he will be regarded as migrant worker, and the application and the provisions of the conventions will apply. Students and trainees are also not considered as migrant workers, but once they take up job, they paid job, they will be considered as migrant worker. Now, seafarers and workers on offshore installations who have not been admitted to take up residence and engage in a remunerated or paid activity in the state are also considered as non-migrant workers. Documented and non-documented workers. Article 5 of the convention provides for documented and undocumented migrant workers and members of their families. On one hand, Article 5A of the convention provides that workers are considered as documented or in a regular situation if they are authorized to enter to stay and to engage in remunerated or paid activity in the state of employment pursuant to the law of that state and or international agreement to which the state is a party. On the other hand, Article 5B of the Convention provides that migrant workers are considered as non-documented or in an irregular situation if they do not comply with the conditions provided for in the immediate paragraph, i.e. the law of that state or international agreement to which the state concerned subscribes. The undulating nature or fluidity of status of non-documented or an irregular migrant worker was judicially reviewed by the European Court of Justice in the case of Hoot against Croatia. The case concerned an irregular or non-documented migrant worker in Croatia who complained that he had been unable to regularize his residence status since his migration to Canada due to fault of his. He alleged that his parents fled Albania in 1960 as political refugees and settled in Kosovo, where he was born a few years later, and that while trying to regularize his irregular status, he was told by the Albanian authorities that he is not an Albanian citizen based on his birth certificate. Thus, he has no nationality, though he has been living and working occasionally in Croatia for about 40 years with no link to other countries or relatives in Albania, who he has long lost their contacts. The European Court of Human Rights, in a chamber judgment, held that there had been a violation of Article 8 of the European Convention on Human Rights, which guarantees respect for private and family life and home. Hence, the complainant is entitled to residence status in Croatia. Now, protections of the rights of all migrant workers and members of their family. The convention, being the ultimate law on protection of rights for migrant workers and members of their family, guarantees a wide range of protections and right to the aforementioned persons. Gentlemen, I can just simply begin to name the rights and protection guaranteed by the convention, such as freedom from discrimination, freedom of movement, freedom from forced labor. But that would be too brief for a presentation such as this, and that would be tantamount to sacrificing clarity on the altar of brevity. We lawyers know that the ABC of every legal writing is accuracy, brevity, clarity, and decorum. And so I am going to buttress my argument with decided cases of local or national judgment by court, so as to clarify some of the sections of the law that I will mention. Now, freedom of discrimination. Freedom from discrimination. Article 7 of the Convention provides that state parties undertake in accordance with international instruments concerning human rights to respect and to ensure that all workers and members of their family within their territory Article 7 of the Convention provides that state parties undertake in accordance with the international instruments concerning human rights to respect and to ensure to all migrant workers and members of their family within their territory or subject to their jurisdiction, freedom from discrimination. Now, this particular provision, Article 7, says that if you're a migrant worker within the state of employment, you should not be discriminated. This is very important. What is this provision all about? If I say freedom from discrimination, and you are not a lawyer, you may not understand the depth of this right. So I'm going to back it up by legal decision so as to clarify the true meaning of discrimination. Now, in the case of Mula and another against Namibia, the government of Namibia enacted an alleged act which discriminated against the complainant. By preventing him from assuming his wife's surname, whereas a woman wanting to assume their husband's surname can do so without following the procedures laid down by the law. The United Nations Committee on Human Rights held that the sex-based approach taken by the act violated the complainant's right to freedom from discrimination. So in the Nigerian case of Adamu and others against Attorney General of Borno State, the appellant filed an application contending that Goza local government of Borno State's refusal to pay teachers who teach Christian religious study, but continue to pay teachers that teach Islamic religious study, leaving the parents of Christian people to pay teachers that teach Christian religions amount to discrimination in clear violation of their right to freedom from discrimination contained in Section 36 of the 1979 Constitution of Nigeria, now Section 42 of the current 1999 Constitution of Nigeria. The applicants further contended that Christian peoples were compelled to attend Islamic and Arabic lessons when Islamic religion people were not compelled to attend Christian religions lessons. These, they argue, constitute a violation of their right to freedom from discrimination and religion. The Court of Appeal agreed with them. Also in Ukeje against Ukeje, the Supreme Court of Nigeria paroled Vivus JS, that is Justice of the Supreme Court, declared void the Igbo native law and custom which disentitles a woman from inheriting her deceased father's estate because that conflicts with Section 42 of the 1999 Constitution of Nigeria, which guarantees freedom from discrimination to all persons. So the issue of discrimination is vast. As interpreted by this by court in these two cases, when you subject a man to do what a woman cannot do, what a woman is prevented from doing, it amounts to discrimination, sex-based discrimination. And look at this case of Ukeje against Ukeje. A woman is not allowed to inherit property just like a man. The court held that that amounts to discrimination. In that case, if a migrant worker is anywhere and the migrant worker is being discriminated on the basis of sex, the court will say no. And discrimination may not only be on the basis of sex, it could be in any other way. We are going to see. Now, number three, right to life. Article 9 of the Convention guarantees the right to life to migrant workers and members of their family. This means that nobody, including the state, can deprive the right to life of migrant workers and members of their families without a just cause. In Francis Corrare against Union Territory of India, the Supreme Court of India held that the right to life includes the right to live with human dignity and all that goes with it. Shrouded in that bare necessity of life are things such as shelter, security, food, etc. In Ransom Kuti against Attorney General of the Federation, the Supreme Court of Nigeria, per the eloquent Kayode Esho, as he then was, opined splendidly that the right to life is a right that stands above all laws of the land, and which, in fact, is antecedent to the political society, he said. This underscored the right to life as the most fundamental right of migrant workers and members of their family, which any administrative decision of the state must endeavor to protect. However, like every other right granted to migrant workers and members of their family, the right to life of migrant workers and members of their family is not an absolute right. This is because it can be legally limited if the reason for terminating a life or life is founded on legal justification, i.e. death sentence, or death that occur as a result of self-defense. These are exceptions to the right of the migrant workers and members of their family to life. Number three, protection from torture. Article 40 of the Convention guarantees to migrant workers and members of their family protection from torture or cruel, inhuman, or degrading treatment. Black Law Dictionary defines torture as the infliction of intense pain to the body or mind of a person in order to punish or extract confessions or information. Torture can also be the intentional infliction of physically founded suffering or the immediate threat to inflict it. In Attorney General against Secretary of State for Human Department, the English House of Lords, per Lord Bingham, held that inhuman and degrading treatment are types of conduct which fall below the definition of torture. They are barbaric, uncivilized, and cruel treatment carried out with the intention of dehumanizing or humiliating the victim. Let's come back home. In Egeneku against Attorney General of another, the applicant sought a declaration that is handcuffing and being paraded on the streets and in his residence at Karemu, Abuja, before his wife, children, and neighbors by the second respondent officers amounts to degrading treatment. The court agreed with him. Similarly, in Kekere Omo against Lagos State, a Nigerian court held that compelling a woman to shave her hair under customary law as a symbol of bereaving or proper mourning of her late husband is tantamount to a degrading treatment and a violation of the complainant's rights to human dignity guaranteed under Section 34 of the 1999 Constitution of Nigeria, which is similar to Article 11 of the Convention. Number three, protection from torture. We have discussed that, so let's quickly go to protection from torture. We discussed that. Now, 4, freedom from slavery. Article 11 of the Convention protects migrant workers and members of their family from being held in slavery or servitude. Slavery or servitude means a situation in which a person or person has absolute power over the life, fortune, and liberty of another. For example, the practice of keeping an individual or individuals in a state of bondage or servitude. Undoubtedly, migrant workers and members of their family are at high risk of being enslaved in foreign countries if care is not taken. Hence, this convention and other international instruments, such as the United Nations Convention concerning migrations in abusive conditions, the Conventions on Promotion of Equality of Opportunity and Treatment of Migrant Workers, etc. In Dame Hadijatu Manikoro against Niger, the author is a Nigerian citizen and a citizen of Economic Community of Western African States. She alleged that she was held in slavery for 9 years in violation of Article 5 of the African Charter on Human and People's Rights, which is similar to Article 11 of the Convention. The ECOWAS Court of Justice said that the applicant is entitled to an all-embracing, all-exclusive relief in reparation for the harm resulting from the practice of slavery. Protection from forced labor, that is number 5. Article 11 of the Convention provides for protections from performance of forced or compulsory labor of migrant workers and members of their family. Forced labor or compulsory labor is a kind of work extracted from migrant workers and members of their family under the threat of penalty. In other words, forced labor or compulsory labor means work which migrant workers and members of their family did not voluntarily offer themselves out to do. However, forced labor or compulsory labor does not include any work or service normally required of a person who is under detention in consequence of a lawful order of a court. You can read down, some of the exceptions are also listed there. But in many, against Attorney General of Lagos State, the Nigerian Court of Appeal had the indefatigable Oputa JSC, as it then was, held that the National Youth Service Scheme is an exception to the right to protection for forced labor or compulsory labor, as stated in Section 34, subsection 1A to C of the Constitution of Nigeria, which is similar to Article 11, 2 to 3 of the Convention. Number 6, right to freedom of thought and religion. Article 12, 1 and 2 of the Convention provides for right to freedom of thought, conscience, religion for migrant workers and members of their family. This particular right is also include protection of migrant workers and members of the family from coercion that will impair their freedom to have and adopt a religion or belief of their choice. The right to choose a religion without fear, bias, or coercion receive a legal interpretation in Medical and Dental Practitioners Disciplinary Tribunal against Okonkwo. In that case, the Supreme Court of Nigeria was called upon to pronounce on the constitutionality of a patient's refusal to undergo blood transfusion on the ground that being a member of Jehovah's Witnesses, doing so was against his freedom of religion. The court held that asking the patient to take blood transfusion is good and it is not unlawful, and so it does not amount to a violation of the patient's rights to freedom of religion and thought. Another case that will portray this argument also is the right to religion, the argument that it's not all time that an immigrant can insist that his right to religion is violated. If the purpose of violating that right is okay and is lawful, that will not be held as tantamount to abuse or violation of the migrant's right to religion. The right to religion, though thought and conscience, has its foundation in the very dignity of human person as known through the revealed words of God. As rightly reasoned by the Supreme Court of Canada, in the case of R against Big M Ding, Mark Limited, the essence of the concept of freedom of religion, thought, and conscience is the right to entertain such religious belief as a person chooses. No doubt, the right to freedom of religion, thought, and conscience that migrant workers and members of their family possesses represent symbols of individual freedom or will, and the foundation of a free state or liberal democracy. In Isanumo against Fayewa, the Nigerian Court of Appeal held that one has the right to choose the course of one's life on account of one's beliefs. However, the right to religion, thought, and conscience, though important, is not an absolute right. This was why the court in Prince against South Africa held invalid the claim of the applicant that the use of cannabis, that is marijuana, is invalid. It's accepted as part, The court held in Prince against South Africa held invalid the claim of the applicant that the use of cannabis is accepted as part of Rastafarian religion, which he belongs, and that preventing him from using it is tantamount to a violation of his right to freedom of religion, thought, and conscience. In that case, the South African court rightly held that preventing the possession and use of cannabis or marijuana by the government of South Africa is right because that is necessary for social harmony, public safety, health, moral, or the fundamental rights of the citizen. So in exercising the migrants, in a migrant exercising his right to religion, thought, and conscience, he must, the migrant must be aware that such a right must not infringe with public order, public health, public safety, and the rights of others. It is not an absolute right. The judicial opinion, the above judicial opinion knocked off the adventurous judgment of a United States court judge in Shebeen against Venner, which states that right to freedom of religion, thought, and conscience granted by law confers on an individual the right to violate otherwise valid law, which are incompatible with one's individual belief. Now, let's look at number 7, 5.7, right to hold opinion. Article 13, 1 and 2 of the conventions provide for the right of migrant workers and members of the family to seek, receive, and impart information and idea of all kinds, regardless of frontiers, either orally, in writing, or in print. The right of migrant workers and members of the family to hold opinion is a complex one. Commenting on the complex nature of the right to hold opinion, the Inter-American Court of Human Rights, in its advisory opinion, stated that those whom the convention applies does not only have the right and freedom to express their own thought, but also the right and freedom to seek, receive, and impart information and ideas of all kinds. Hence, when an individual's freedom of expression is unlawfully restricted, it is not only the right of that individual that is being violated, but also the right of others to receive information and ideas. Let's see the case that portrays that. The issue of right to hold opinion and expression came up for interpretation by the court in the case of Okoje, that is an archbishop, against Attorney General Lagos State, and Adewale against Zakande. In those cases, the Supreme Court of Nigeria held that Section 36 of the 1979 Constitution, now Section 39, which is similar to Article 13, 1 and 2 of the Convention, confers right on individuals to establish any educational institution as a medium to disseminate knowledge, and that the freedom to hold opinion and express it enshrined in the Constitution covers information and thought received in such schools. You see the Turkish government having school in Nigeria, Ghanaian government having school in Nigeria, US government having school in Nigeria. This form part of their right to opinion. They can use that right to opinion to indoctrinate or teach their people that attend such school what they believe in. It is their right, and it's the right of all immigrant workers to hold opinion. Right to privacy. Article 14 of the Convention guarantees the right of migrant workers and members of their family to privacy. This means that the right of migrant workers and members of their family to privacy, correspondence, or other form of communication cannot be arbitrarily interfered with or their honor and reputation unlawfully attacked. The right to privacy of migrant workers and members of their family connotes their right to determine when, how, and to what extent information about them can be communicated to others. There are two clear cases we are going to cite here. The case of Naomi Campbell against MGN. Now in London, the Daily Mirror of London had a story about Naomi Campbell. Naomi Campbell is a supermodel of Kenyan extraction. They want to publish a story about her that she has been admitted to a rehabilitation center for drug overdose. The woman objected to that and went to court. The court held that she has the right to either allow or not. And if the Daily Mirror go ahead to publish that story, it's against her right of privacy. And so the court stopped the Daily Mirror. The second story is also about right to privacy, and it is between Her Royal Majesty, Princess Diana, Princess of Wales, against MGN. The company is a mother company of Daily Mirrors of England. They obtained pictures of Princess Diana and they wanted to publish it. Princess Diana went to court, and the court agreed with her that that kind of picture cannot be published without her permission, and that doing so would be an infraction of our rights to privacy. So migrant workers have the right to privacy and they can exercise. But let me also warn that.
Dr. Dike, you have sorry, sir, you have 3 minutes.
All right. Then when you go ahead, what you will see, you see protections against arbitrary deprivations. The section of the law that provides for that is there. The case that also buttresses is there. Protection against right to personal liberty, the provision of the law is there. The case that buttresses is also there. Then you go to right to personal liberty is there, and the cases that buttress that are also stated. Right to humane treatment is there, and the case that buttresses it is also there. Right to equal treatment is there. The case that buttress explain or eliminate what right to equal protection treatment is also there. Then when you go further, you also right to freedom from retroactive legislation is there. Right to freedom from imprisonment on account of breach of contract, freedom from classification, freedom from collective expulsion, right to consular and diplomatic services, right of recognition, freedom of association, and freedom. You also right to social security, right to medical care, right to registration of birth certificate, and the right to cultural identity, right to education, right to transfer of earnings, right to be formed, freedom of movement, freedom of movement. The case that portrays all these things are there. Then freedom to participate in public affairs is there. In conclusion, the affirmation and establishment of basic human rights norms that protect the rights of migrant workers and members of the family in a comprehensively codified document by the United Nations General Assembly showcase the organization's approach of the inevitability of migration and the positive roles migrant workers and members of the family plays internationally. No doubt, the wholly applicable convention with its avalanche of protected rights of migrant workers and members of their families will further deepen the positive role they play in international relationships and development. The weight of the above conclusion cannot be overemphasized if one weighs in the matchless truth that migration has stratified to some extent extermination of persons or group of persons, made others to achieve or live their dreams, and on the whole makes our world a better place. The above assertion is unassailable and obviously is one of the take-home values of migration. Thank you for listening.
Thank you very much, Dr. Adakole, the Dean of Law, for that presentation. This is again an indication of the complexity and dynamism of migration within the context of global studies. We appreciate you. I have the following for comment, and I will round up with general house cleaning of information. First to go will be Dr. Mbanefo. I think it's a very short one. I don't want to repeat a comment, but I'll give her the space to Mbanefo. You are being unmuted, followed by Dr. Williams, Elmina. Dr. Williams also will make his comment or questions, and then Dr. Ademola. So I'm muting all of you as I speak, but please control your environment there. Dr. Ademola, I'm calling her from Ilorin. She is not just a peace educator, but she's also a lawyer. Maybe she has something. I'm actually drafting some of you. So you'll be wondering, why is he calling me? I didn't show interest. So that's a draft. Then number 5, Dr. Akujobi, the immediate past dean, I believe, of law. Dr. Akujobi. Then we'll have Professor Sogolo to also, if I've been trying to see who is now, somebody signing as now. I'm not sure whether that is the vice chancellor or the registrar. I would like to, see if they have any comments. I've asked Dr. Akujobi to unmute herself. Then Professor Sogolo, let me see, I think okay, you're signing as Prof. PC. Prof. PC, okay. So I've asked you to unmute yourself, sir. And then please just indicate by typing. I do not think I have, I won't be able to scroll up and down to see your hand or the Emicon, but if you could just indicate by typing in the chat, then I can see it as it pops up. Dr. Mbanefo, please, 10 seconds or 5.
Good morning, Director. Thank you. Thank you very much, Director.
Thank you, ma'am.
I want to appreciate, greet everybody, our amiable Vice Chancellor, the Director of Migration Studies, all professors in the house. Good morning to everybody. I thank the Dean of Law for this wonderful presentation. My only observation is that these slides are very loaded, 1. 2, in fact, the topic is talking much of freedom, rights of migrants and the violation of their freedom and rights. Our topic, I think, I suggest that there should be something to show about their rights in the topic. The topic is talking only about the protection. So I think we have to put something about the rights and the violation of these immigrant inside the topic. That's the only suggestion I have to.
Thank you, ma'am.
Thank you very much.
Number 2, Dr. Williams, make it snappy also.
Thank you, Prof. Thank you, Dr. Dike. She has just pointed it out. The PowerPoint is too worded. 46 pages for a presentation like this is too worded. Secondly, I would like to suggest to him, the topic is where the problem is. Because if he says migrating to work, an insight on legal protection of migrants, I think if he can take this topic like this, migrating to work and migrants' rights, then an insight on the legal protection of migrants, so that he will be able to capture all of these issues that he's been able to address. So I think it will also add value to the work. Thank you very much.
Thank you, Dr. Williams. I kindly also type that out or test it to the Dean of Law so that he can consider as he revises paper. Next is, which number 3? 1, 2, 3. Oh, okay, I think I missed the number. Dr. Adimula, our regular guest from University of Ilorin. Dr. Adimoke, Dr. Adimula, I ask you to unmute yourself.
Yeah, thank you very much. Thank you very much, Prof, for the opportunity to make my contribution. I want to commend the presenter for the presentation and particularly for the case laws that were used to illustrate some of those points. The only contribution I want to make briefly is based on the topic of the presentation. I'm just looking at the possibility of enhancing the paper by including the gender perspective to that presentation. And here I'm talking about migrant women, their issues, especially considering the fact that most women, when they are married and they are migrating with their husbands, they find some issues very problematic in recognition of their rights in their respective host communities. And some cases, it has to go to the extent that women need to obtain the consent of their husbands for traveling documents and all this. I believe that the right of women in this respect could also be captured to show that women also have a right to work wherever they follow their husbands to migrate into. And some of these issues can be well captured to explain the gender perspective of the migration hanging under discourse. Thank you very much.
Thank you very much, Dr. Adimola. My spirit was telling me you will ask questions and also drive us to the issue of gender. And I think is important. I'm supporting you on that. Why? Because as far as the 18th century, it was Abigail Adams, the wife of the second president of the United States, John Adams, that wrote to the founding fathers when they were crafting the Constitution. And the most popular phrase in a letter to the men that gathered, no single woman, to the men that gathered in Philadelphia was, quote, "Whatever you men do in Philadelphia, remember the ladies." Sincerely, the most revered constitution in the world, the US Constitution crafted in Philadelphia, did not remember those that were forced into migration. Neither did it remember the ladies until 1901. And in 1901, it was just the white ladies. So I feel you, Dr. Ademola, and I think is an area that we'll need to look into. Perhaps November is still open for 3 slots, presentations. You may want to give us a paper, or maybe Dr. Akujobi, maybe both of you can combine. So Dr. Akujobi, the immediate past Dean of Law, can you please speak? I know Professor Sogolo will go next. Dr. Akujobi. Dr. Akujobi. Okay, she's not there, or she's having technical issue with audio. Can we have Professor Soglo, Professor Emeritus Soglo? Let me see, Baba signing as PC. I'm not sure if he's willing, is talking or not. Ask to unmute. You can unmute yourself, sir. Okay. Well done, Dean. That was okay. This is Dr. Akujobi.
It's all right. I've unmuted myself. Yes, okay. I've unmuted myself. In fact, I'm using my laptop this time. I used to use my phone. So what is showing there is slightly different, Professor PC rather than my name. And I was wondering, yes. I didn't know how to fix that. Maybe before the next presentation, I'll be able to fix that so it will show my name clearly. I think that this presentation is a rather technical one. Technical in the sense that there's a lot of legal, professional sites, citations that are difficult to question. But and I think it's important in the sense that we're really talking about the right of migrants. Which makes it, convenient for anybody who has left this country to another country to feel rather secure in the sense that they have rights which are, binding on even on the host communities, and that's very, very important. But I want to know the part that wasn't too clear to me. When you have violations, which court really takes care of those violations? And then if that is to say, if your host community violates your right as an immigrant or a migrant, now to what court do you take that? Is it international court or the court of the host communities? Or, yes, or your own court at home? That's the clarification I wanted to know. I'm sure you made that point, but I'm not too sure. I want to know if there are special courts that handle cases like this where the rights of immigrants are violated. Thank you very much.
Thank you, sir. Dr. Akujobi. Dr. Akujobi, ma. Dr. Alero Akujobi. You are on mute. I think she's still having that technical stuff. Okay, while we're waiting on now, let me just, I can't see any other hands up or note. Let me make the following remarks. I've said that the issue of migration is so complex and dynamic. It is transdisciplinary, so it cuts across all disciplines. And I love the opening remarks of the presenter because we plan, hopefully in the new year, if not November, we plan to do a kind of a poetic verses. I have done in the past, my research focusing on poems that I will not tell you the secret because it may not be relevant or catch your interest when we start it, but I'll leave it as that. But the narrative about that the guest presenter gave us is so succinct that I wish we can always weave the science, the art, the humanity of such presentation to make it so lively and interesting and intelligible to a non-expert. Yeah, once I stop, you can take off, Dr. Akujobi. I thank you for respecting the fact that I'm still speaking. Also important is to let all of us know that we have just 3 slots remaining in November. We are so busy, and I've shared that timetable with you. Just 3 slots. December, we will take a break until January. I think but I will get approval of the Vice Chancellor for that. And I'm sorry mentioning it. That is not my style. But I'm thinking we need to rest December. If not, we do twice in December. But we are so fully booked until the first week of November is gone. And 3 slots in November is going to be filled up. I'm saying this because of the fact that we also have quarterly reports that we produce one, and the Vice Chancellor has a copy. I think we are planning to give the library a copy, and but for the Migration Observatory, that would be on our main website. The website is still in the making. What we have on the main university website is just for general info, but you have digitization of some of the things we are doing, because these are relevant. It's very, very key. One for the fellows, particularly the junior fellows, but more importantly, the sustainability of this center in terms of grants. Oil is dwindling down. The money, the proceeds from oil, as those in business admin, Professor Samaila, Dr. Zigbo will agree with me, is becoming a challenge. For the center, we must begin to think out of the box. So the observatory, migratory, and the website is very, very crucial to us seeking that grant, because they will check. And that is the only way they can get to know us. IOM, several organizations, ECOWAS, giving us grants. So we will be there, and I thank you. So last but not the least is the fact that we have papers already turned in for peer review. I won't mention names, and I won't mention those people that will be reviewing. It's supposed to be blind review, but we will do justice and then equity. And guess what? If you are presented, you will get published with mentoring. We do not review to kill you or kill your paper. No, that is not scholarship is about. Scholarship is about bringing you up, lifting you up, rather than bringing you down. And that has been my own philosophy, what I have learned since my days in LASU. It's been a while. I saw my pink slip, but I'll talk about my pink slip some other time. I didn't believe I was earning 500 and something naira in 1991 as an assistant lecturer. I was just laughing this weekend. Lastly, the certificate of presentation is ready. We promise to give certificate of presentation to all of you that are presented is our token of appreciation. Please accept that, okay? And you can contact Mrs. Alabi, the assistant registrar in charge of that in the center, through the center's email address, CEMGS@now.edu.ng, and for general correspondence. Dr. Akujobi, you have the floor, ma'am. 20 seconds. Dr. Akujobi. Oh, she muted herself. Let me, I'll unmute you. Dr. Akujobi. Please unmute yourself, Dr. Akujobi. I hope I will not end up in the magistrate court in Guagualada or FCT with all these lawyers. Well, if she's not unmuting, or maybe she's still having difficulty, let me just read what she sent to I believe it's for everyone, but let me read it as we round up. Well done, Dean. That is the guest presenter. That was a succinct presentation in trying to cover as much as possible the legal rights of migrants. However, I observed that the paper goes beyond the rights of just migrant workers, but to all migrants. So kindly respond to these comments and questions and observations. Where are you now, the guest presenter? Dr. Dike, are you there? Oh, did we lose him? Okay. Please unmute yourself, sir. Dean of Law. And quickly respond. You have 2 minutes. Sir, unmute yourself.
You still is okay. Can you hear me now?
Yes, sir. Go ahead.
All right. I think I'm happy with the question I've just gotten, but I'll briefly answer it this way. Number one, Professor Nefu talked about protection too wide. I could safely list out the sections of the law that provide for the protections and those rights that are guaranteed by the convention. But in an academic situation such as this, we all come from different, we are not from the same background. So I need to adumbrate my discussions of these sections with cases, because cases are the keys that unlock statutory interpretations. And that is why you see it for every session, what is the true meaning of this right? I try to do that. Then somebody also said that the topic is too wide. You know, the embracing nature of migration means that if you have to cover migration, you cover a lot of things. And in order to start from a clear path, I quickly say that this particular presentation is going to be about migrant workers and members of their family. People migrate for different purposes. One, either as a leisure to invest, to have training, but there are some that migrate to work. So for those who are migrating to work, these are your rights and protections. And again, a lady from Ilorin talks about the rights of members or spouse of the migrant. You see, this particular law do not only protect migrant workers, it is for migrant workers and members of their families. Women, children, they are all protected. A law that seeks to abolish discrimination on the basis of sex cannot promote discrimination. So this is not against, it's not about women, it also protects the right of women, the husband, the wife, the children, whatever. They are all protected here. So that is for that one. Then my learned friend talked about the paper not covering other things. Just like I said before, please take it that this particular aspect I'm discussing is migrant workers. Migrant workers, what are the rights of migrant workers? Because some of us have not migrated. I may want to migrate, and others may also want to migrate. So for those who want to migrate, let them know. He talks that the rights are not only for migrant workers. No, the protection, the United Nations Conventions on the protection of rights of all migrant workers is not for other migrants. There are others who migrated, like if you are going on tourist, you are a migrant. If you are going to invest, you are a migrant, but you are not treated as a migrant worker. If you are going as a student trainee, an envoy, you are a migrant, but you are not covered by this convention. And I stand my feet. These conventions is not for other forms of migrants. It is only for migrant workers, those who migrated and are working. So if you migrate and you are not working, if you're a refugee, you are not working, this law does not cover you. Is that
Thank
okay?
you very much. I think we have to increase our time spent on border patrol. Border patrol, I believe, is channel 22 on what is it? Go TV. I don't know what channel it is on DSTV.
Mr. Chairman, and in fact, if you migrate and you are working, but you don't have the paper, you are not documented, you are an irregular migrant working, this convention do not cover you.
Okay, all right. Thank you very much, and I thank each and every one of you again for participating, finding the time. I wish you all the best. So all the days we can migrate to and go and see Professor Mande's committee. Thank you all. Stay blessed. Bye-bye.
Bye-bye.
Bye.
Bye-bye.